Are IRAs protected from lawsuits? Have you ever wondered how safe your individual retirement accounts are from lawsuits? This is an important question, especially when it comes to planning for the future. Let's break down the details to understand the protections available for these accounts. Individual retirement accounts, or IRAs, have different levels of protection based on the type of account, the nature of the lawsuit, and the laws in your state. Generally, IRAs are protected from creditors during bankruptcy under federal law, but this protection is not foolproof. Employer-sponsored retirement plans, like 401(k) accounts, usually have stronger federal protections compared to IRAs. The protection of IRAs largely depends on state laws, which can vary significantly. In some states, IRAs might be at risk from creditors or legal claims outside of bankruptcy situations. This means that if you live in a state with less protective laws, your IRA could be vulnerable to lawsuits. Another important aspect to consider is inherited IRAs. A key ruling by the United States Supreme Court in 2014 stated that inherited IRAs do not enjoy the same protections as original IRAs during bankruptcy cases. If a beneficiary inherits an IRA and later faces bankruptcy or legal claims, those inherited funds may be accessible to creditors. This distinction is vital for effective estate planning, as it exposes inherited IRAs to potential claims. One effective strategy to protect an inherited IRA is to place it in a properly drafted spendthrift trust. This type of trust restricts the beneficiary's access to the funds directly, allowing an independent trustee to manage distributions. By doing this, the IRA assets can be shielded from the beneficiary's creditors and legal claims. However, it is essential to have an attorney who understands IRA and trust law draft this trust, as a traditional revocable living trust will not provide the same level of protection. State laws can also play a significant role in the protection of IRAs. Some states offer stronger protections for both original and inherited IRAs against creditor claims. For instance, Florida has specific laws that protect inherited IRAs. Because of these variations, it is crucial to understand the laws in your state if you want to maximize protection for your retirement accounts. When planning for asset preservation, consider how IRAs will be treated if the beneficiary faces lawsuits or creditor claims. Utilizing trusts designed for IRA protection can help safeguard retirement assets for heirs, ensuring they are not depleted by creditors. Elder law attorneys often recommend integrating IRA protection strategies into wills and trusts to preserve retirement funds for intended beneficiaries. In summary, while employer-sponsored plans like 401(k)s generally have strong protections, IRAs are primarily protected by state law and may be vulnerable, especially when inherited. Proper estate planning, including the use of spendthrift trusts, is essential for shielding IRAs from creditors and lawsuits.